Have you seen those viral clips where people stand in the courtroom shouting, "I do not consent. I stand under common law," and then within seconds they're either ignored, fined or escorted out? From the Freeman of the land movement to people waving the Magna Carta 1215, in modern courts these arguments keep failing. But why? And here's the sad truth, and that's most of these defences collapse because they're built on pseudo-law, made up legal theories that don't hold up. Meanwhile, the real power lies in areas where most people don't even look at: citizenship law, expatriation, and international human rights law. So if you've been searching for why Freeman of the land fails, or does the Magna Carta still apply, or can you really opt out of government, then stick around, this is going to surprise you. So let's cut straight to the chase then. Common law. The Freeman of the land, or the sovereign citizen movement, is based around three main ideas. Statute law only applies if I consent. Common law is higher than Parliament or Congress. And the Magna Carta gives me rights that the government can't touch. Now this does sound quite powerful when you first hear it, but then the problem is simple. The courts reject these arguments every single time. In the UK, the judges openly call this pseudo-law. And in Canada, the famous Meads versus Meads case in 2012 produced a 200+ page ruling where the court dismantled these arguments, calling them organised pseudo-legal commercial arguments, OPCA for short. Since then, the judges worldwide have been trained to spot this instantly. And in the US, the sovereign citizens approach has been struck down every time, whether it's from parking fines or tax evasion. And what about the Magna Carta? Well, let's be clear. Out of the 63 clauses in 1215, only 3 still remain in UK law today. 3. The freedom of the English Church, the liberties of the City of London, the right to due process, which is already protected under the Human Rights Act 1998, and the European Convention on Human Rights Article 6. And that's it. The rest were repealed centuries ago. So when people hold up the Magna Carta in court, the judge doesn't see a trump card. They see somebody that doesn't understand law. Now let's talk about common law. A lot of people think that common law means the people's law, some pure ancient system where the state can't touch you. But in reality, common law just means judge-made law. Decisions built up through court rulings over the centuries. It works alongside statute law, which is written law passed by Parliament or Congress. And here's the key fact, and this kind of shocked me as well. Statute law always overrides common law if the two conflict. And so if Parliament passes an act that says you have to pay road tax, you can't just say, I stand under common law, I don't consent, because that's no defence. Ask all the people that have tried it. Because indeed, this is why so many people who have gone down this argument have been fined, lost their homes, or even jailed. And this pattern is across the UK, Australia, America, New Zealand, Canada. Bold claims online, but total defeat in the court. But this is where it gets interesting. If you really want to challenge the system, the powerful tools are not in the Magna Carta or pseudo-law theories. They're in nationality law, expatriation, and the international human rights law. International law actually says quite a lot about citizenship. The Universal Declaration of Human Rights, Article 15. Everybody has the right to a nationality. Nobody should be arbitrarily deprived of it. 1961 UN Convention on the Reduction of Statelessness. Governments can't just strip you of your citizenship, not unless very strict conditions are met. The European Convention on Nationality 1997. You have the right to acquire, keep, or change nationality. These aren't just words, courts enforce them. For example, in the US, Afroim and Rusk 1967 ruled that the government cannot take away your citizenship without your consent. That case set the modern standard for citizenship protection. In Europe, Gomid and others versus France 2020 saw the European Courts of Human Rights uphold nationality deprivation for terrorist convictions, but only because it was proportionate, targeted dual nationals, and came with proper safeguards. These are the real battlegrounds, questions about nationality, statelessness, and the limits of government power. So let's talk about expatriation. Expatriation means renouncing your citizenship, and unlike pseudo-legal law arguments, this is legal and it's a recognised process. In the US it means going to a consulate, signing an oath of renunciation and paying a fee. In the UK you can renounce your citizenship, but only if you have another nationality, to avoid becoming stateless. In many EU states there are strict rules, but the principle is the same. You can cut legal ties with your state, but only through proper procedures. Why is this powerful? Because it's the only recognised way of saying I do not consent to this government's authority over me. But here's the catch. You lose the right to live in that country. You may still have tax obligations. If you don't have another nationality to go to, if you don't have another nationality, you risk being stateless, and stateless people often face more restrictions as opposed to less. So yes, expatriation is legally real. Unlike Freeman and the land stuff. Courts respect it, but it does come with real life consequences. And so just a quick recap, and to bust a few myths. Does the Magna Carta still apply? Only 3 clauses remain, and they're already covered by modern law. Can I stand under common law only? No. Statute law applies to everyone, and it overrides common law. Why does Freeman of the land arguments fail? Because they're pseudo-law, not recognised by the courts. So how do you renounce your citizenship legally? Through expatriation, following your country's procedures. Is expatriation a loophole? No, it's a recognised legal right, but it comes with serious consequences. If you want real power in law, you need to operate where the real debates happen. Nationality law, expatriation, and human rights. So here's the bottom line, everyone. The free man of the land, Magna Carta, sovereign citizen, those defences fail because they're built on fantasy. They ignore the actual structure of modern law. But expatriation, nationality law, and international human rights law are real, powerful, and actually used in courts worldwide. That's where governments get challenged, and that's where change actually happens. If you've enjoyed this video and you found it useful or entertaining, please do hit the like and subscribe button. Share the video. Please leave your thoughts in the comment section. And until next time, look after yourselves, and I look forward to speaking to you all again soon. Bye for now.